Hello, this is Rex Crandell, and today we're going to be talking about transfer on death deeds. It's a fairly new deed in California, and it works differently than other type deeds. It has peculiarities. I think the legislature set it up so that people with moderate means could have some type of estate planning tool without a full-blown trust, because it may cost less to set up a transfer on death deed, but there are some significant disadvantages of working with this document. So most deeds, well, some deeds like joint tenancy and tenants, community properties right of survivorship, when one of the owners dies, it goes into the survivor ends up owning it, the asset. The transfer of death deeds are a little bit different, and they do avoid probate at some downside cost. So they're called a beneficiary deed or transfer on death deed. Allows the owner of the property to designate a beneficiary right on their deed, and it's revocable. So unlike a life estate where you give someone the right to stay in the property, like yourself, and then after you die, it goes to another person, the remainderman, those are not necessarily revocable, where this transfer on death deed is actually called a revocable transfer on death deed. And so the beneficiary gets no right. They have no say if you decide to revoke it or change it in the future. It's a straightforward way to avoid probate, although there are some situations where it really kind of acts like probate. Okay, so some of the advantages of transfer on death deeds. Yes, we mentioned avoids probate. What is probate? It's a court procedure where it might cost you tens of thousands of dollars to transfer property because you used a will or died intestate, and you have to get a judge to sign because the decedent can no longer sign documents. And this revocable transfer on death deed does avoid probate. It's fairly simple to straightforward. You name who the grantor is and who the beneficiary is. There's a lot of requirements. You can only, if you have three beneficiaries, they end up having to be equal owners. The owner of the property still gets to control all the property during its lifetime, and you can later revoke it. It perhaps costs less than preparing a revocable living trust, but the downsides, whenever you make a mistake on these, you end up in probate anyway. And since I'm an estate planning attorney, I think a trust is a better way to handle these types of situations. It does avoid conservatorships because the incapacitated person doesn't need to change anything and it's already planned out. There are some tax situations with the transfer on death deed, and when someone dies, they get a stepped up basis, which means for capital gains that if, say, father to daughter, and the father dies, daughter gets the house, and for capital gains purposes, if they were to sell the house the next day, there would be no capital gains, where if a father sold the property directly before death, then it would have been a capital gain. So here are a few of the disadvantages of the revocable transfer on death deed. It's only for certain kind of property, a house, a condo. It can be farmland as long as they're up to 40 acres, as long as there's one house on it. It can be a condo in a multi-unit building, and there's a limit. It can be no more than a 4-unit fourplex to be able to use this instrument. Okay. So there's another one of the problems with it. Say you name a beneficiary and the beneficiary dies before the property owner does. Well, and then the property owner dies and there's no beneficiary. So you set this up to avoid probate, and guess what? It's going right into probate because there's no right in the statute that allows you to name an alternate beneficiary where you can with a trust. There's another problem we've seen where if a beneficiary is named and they're under 18, at the time the owner dies and it goes to the minor can't do anything with it. They either have to get a guardian ad litem, which is a conservatorship, guardianship of the estate, or the minor has to wait until they become 18. They can't even sell it. The transfer on death deed does not provide any creditor protection. In fact, it's worse than other types of transfers, because when normally on a trust, when someone dies and it goes to the beneficiaries, the trustee, or correction, the beneficiary is not liable for the personal debts of the decedent. But on this deed, when the owner of the property dies and the property goes to the beneficiary, all of the unsecured and secured debt follows to the property, to the beneficiary. So what does that mean? Normally, it's not unusual for property when someone dies that the loans, the mortgage or no deed of trust on the property travel with the beneficiary. No problem. That's normal. But in this case, the credit card debt, the unsecured loans, those debts go and the beneficiary gets is liable for the personal credit card debt, unsecured debt of the decedent, which to me is horrible. Another problem that these deeds create is that there's a litigation period after a person dies and it goes to the beneficiary for 3 years, that the other beneficiaries that were potential heirs can sue and tie up the property. And for that reason, title insurance companies will not issue title insurance to beneficiaries of transfer on death deeds for 3 years after the decedent dies. And so you can see these situations where, say, an adult child was living with a parent and they were on Social Security and the house payments were being made, and then the parent died, their pension stopped, their Social Security stopped, and now the adult child's living there and they can't keep up the payments. Well, they can't even hardly sell it because nobody's going to buy a property with no title insurance, or you're not going to get title insurance for 3 years. So I can see what the legislature was doing with it. And what they did is they put some of the negatives of a probate, like if the property had gone into probate, the unsecured creditors can file a claim against the assets. Well, this is not a probate, but the creditors get the right to go after the beneficiary. And it's not like it's any secret. I looked it up, and the Social Security Administration, when someone dies and the transfer on death deed, Social Security notifies the 3 credit reporting agencies that this property owner died. And so then all the unsecured creditors know that they can go after the beneficiary for the unsecured debt. It's horrible. I mean, it's unheard of in other kind of estate planning documents that you receive property. Okay, oh, goody, I got an inheritance. Oh, well, what about this extra 75,000 of unsecured credit debt? It's horrible. And then you can revoke it at any time, but they added a new feature in the law in 2022 where the beneficiary has to notify all of the heirs of the transfer on death deed, and then they have to file another notice with the county recorder stating that they told all the beneficiaries about the transfer on death deed and that they gave them proper notice and they have a right to challenge it. So let's say a parent decided one child could have the property and the other one isn't, then you have to notify the child that didn't get the property. Oh, by the way, dad died. I got the house. You didn't get it. You get to sue me if you want, and I'm liable for their personal unsecured debt. And that extra notice is required in addition to, there's a separate form that needs to be filed after a transfer on death deed to clear the original owner's name from the property. And it has quite a bit of detail in that disclosure form. This is a summary of some of the disadvantages. So some of the restrictions, I mentioned the kind of property, only like residences. It must be recorded when you sign and notarize a transfer on death deed. The deed itself has to be recorded within 60 days of when it was notarized. No other estate planning document has that requirement. As I mentioned, the Revocable Living Trust is much easier, and it's has a lot more flexibility. In terms of the beneficiaries, you can name one person, two persons, three, or a charity or a legal entity, fine. But another problem of this deed, let's say you have a beneficiary, and let's say there's two beneficiaries and one of them dies. Well, that person who died does not, their children or heirs do not get the property. It goes to the only survivor in this example. And you cannot name unequal shares, 80-20-20, whatever, or 80-10-10. You're not allowed to have contingent beneficiaries. If A isn't alive, then give it to Uncle Jed, whatever. You cannot do that. The beneficiary has no right to make any claim on a transfer on death deed. And the personal debts of the decedent or a major disadvantage. This is an example of a transfer on death deed that someone would fill out. You put where you want the property tax, a parcel number, legal description, and then list the beneficiaries. And it has the requirements. And so it has to be notarized. In addition to being notarized, it has to have two witnesses. There's no other estate planning document that has a triple set of documentation. I think the legislature thought that the people who use these weren't very bright, so we're gonna make them notarize it plus 2 witnesses, see, the person sign it. It does work, it does transfer on death. But the downsides are amazing. This is the instruction that comes with the form when you're filling out one, if somebody was trying to do a do-it-yourself deed. And it gives all the specificity on what needs to be done. There's instructions that are good in terms of how to get the document filled out. I mean, you can get it filled out. It's just that if you try to do anything, you want to change it, you got to go back and record another document with the county. And if it fails, you're going right into probate. So this is with the bubble examples, how to fill out the form itself. And here's what I'm saying about, you have the person signing it in front of a notary plus 2 witnesses. Then if you want to revoke the transfer on death deed, there's a separate form. And I don't see how people with moderate means, the legislature thinks that this is going to benefit them with all the complexity that they put in the statute. But you revoke a transfer on death deed in this manner with all the requirements of the parcel number, documentary transfer tax, and legal description, and the notary and witness rule. So this is another example of one, and there's quite a bit written about it, but in conclusion, the detriments outweigh the benefits of using it. It's high risk. You might end up in probate anyway. And for a few extra dollars, you could get a trust to transfer your property, have complete flexibility. And by using this so-called cheap and effective, people for moderate means people to fill this out, you make one mistake in the requirements and you're going to probate anyway. So there's, to me, I would never use it. I would not suggest it. The downsides are significant. And if you just use a trust, a revocable living trust, you're fine. So if you have questions about this, you can call our office. I'll be happy to talk to you about them, and also perhaps review your existing estate plan.